Hello. How much does it cost to sue for defamation? That's a very important question, actually. Maybe you heard before that civil justice, as opposed to criminal justice, civil justice system, civil litigation, is much more about money than something else. And of course, there are situations when it is about child custody or it is about some animal or some emotionally loaded piece of property or something like that. But very often, probably mostly, at the end of the day the question is who will receive what, who will pay what. Not only those questions, of course, but those are more or less a majority of civil law cases, at least of those which eventually come before a judge. And the lawsuit in defamation is one of those, actually. Because, of course, if you feel offended, if you feel that your reputation and dignity is suffering or had suffered, you want some sort of retribution. But the lawsuit itself is costly, and then if you ask the judge to remedy the damage, you'll have to present some proof of the value of the damage. So again, it will be a question of money at the end of the day. And sometimes you even can receive an apology. You win your lawsuit, but you pay much more than you actually lost before this defamation, because of this defamation. And then you feel like you punished yourself, and then you start asking, like, where is justice and all of that? So, in a sense, only in a sense, before starting a lawsuit, you should think of return on investment. Meaning, like, how much will it cost you and how much are you going to receive because of that? What's the value of the compensation for the damage, and what's the value of going further on, having received your compensation or retribution for this attempt on your dignity and so forth. Of course, it might depend on the value of the reputation, because if you're a politician, for example, or a rock star or a movie star, well, some might argue that your reputation actually values less, because, well, everybody is expecting some like dirty gossip and rumors about those people. Some, on the contrary, would argue that it's of a greater value because the celebrities are more prominent people and their reputation is more important for them and for their income and so forth. But in any case, there is something to calculate. So there is a question, how much? And then you come to your lawyer and ask this question, like, how much will it cost me to sue for defamation? And your lawyer becomes rather vague about that, and for a good reason. Because most of the time your lawyer cannot reasonably predict how much will it cost you. Not because the lawyer is trying to hide something from you, because if your lawyer is quite busy, there is no interest in making more of your case than it is. But the point is that there is always a second party, another party, sometimes even more than one, with their own lawyers. And it's pretty much unpredictable what they will do. Even though nowadays we have a case protocol, which should probably tell you what kind of actions will be taken from both sides, but still, there might be applications in case management, there might be unexpected applications, and the applications to authorize those applications and so forth. So depending on how vindictive, how quarrelsome, how aggressive is the other party, a case with the very same facts and very same allegations might be less costly, more costly, and like the difference might be a significant one. Of course, you'll ask your lawyer for his hourly rate, and it will vary, and you'll probably shop around and verify the reputation of this and that lawyer against his or her hourly rate and so forth. But again, even with that, there will be a question like, how many hours will be spent? And again, we're back to the answer, well, I don't know. It's more or less unpredictable. You can ask, of course, what was the average for a similar case or similar cases in your own practice. And again, you can compare answers from different lawyers, but that will be information based on some previous experience, previous cases. Your particular case, again, for the very same situation, might take years and years and years as opposed to 1 to 3 years for some other case, or might be settled very fast if the other party is really reasonable, and maybe the case will not even go to court because of that. Again, with all the same facts or very similar facts around. Also, while your case preparation is ongoing, some new judgment might come out, and that will just turn upside down the whole legal strategy and your case theory and the way it was prepared before, and your lawyer might come to you asking for new evidence and so forth. Again, I'm not saying that it happens every time, but it can happen. And because of that, your lawyer reasonably cannot tell you, okay, this will be this amount of money. But again, what you still should take into account is what kind of expenses are there or will be there, like more or less for sure. If there is a court application, because again, when you come to a lawyer, there is no guarantee that there will be a court application. It all might end up in a letter of formal notice and negotiations and settlement. But if there is a court application, then there will be court fees. They're not that high in Quebec, actually, but very often they depend on the value of the amount claimed. So it might be a couple of $100, it might be significantly more than that. Because to start a lawsuit, you have to formally notify the other parties via bailiff usually. Then there will be bailiff fees. There will be lawyers' hourly fees. And if there is a need to prove some particular damage or some particular situation, or if the situation is like very much technical or financial, well, beyond commonsensical, let's put it this way, then you might need an expert in writing, a forensic expert, a financial expert, medical expert, so forth, fine art expert. Then, very often, there will be pretrial examinations, and if that's the case, which again, you never can predict with 100% surety from the beginning, but if there is such a thing as pretrial examination for both parties, or one of the parties, or many parties, then there will be stenographer fees, in addition to your lawyer's fees. Maybe the other party is significantly poorer than you are, or maybe the other party or the other party's lawyer could prove to the judge that your case is completely unfounded or some other reason, and the judge might order you to pay the other party's lawyer's fees or just deliver some provisional costs to cover the other party's expert, for example. So again, that may be added to your fees, to your expenses. In some situations, you might suspect something, but you might have no evidence of that. So the idea is, not very often, but quite usual, to hire a private investigator, online or like electronic documents, or just a real private investigator who would just follow up somebody and to observe some property, make some pictures, well, within the limits of legal requirements, of course, but still. So again, there is some hourly rate. There might be a notary as one of the specialists. There might be some accountant as one of the specialists, whose documents, whose opinion you'd need. And again, you will have to pay those people. Those specialists, not as people, but as specialists, again, for their services. There might be a need for an interpreter And if you're asking for a witness, or if you're going to testify yourself using an interpreter, it won't be the court who will pay for an interpreter, it will be yourself. So again, well, there are situations, but mostly. So again, that's another expense, that's another factor to consider. Of course, there will be administrative expenses, transportation, postal, some delivery services like couriers, sometimes like warehouses to keep some documents or some property, some safety deposit boxes. Depends on the situation. There might be, for example, a need to pay some notary or another specialist to be your escrow agent, to keep some money in trust while the litigation is ongoing. So there are many expenses to be just taken into account when you're getting into a litigation. I'm not saying that in every litigation you'll have to cover all those expenses. Those are just examples. They might be less, they might be more, but more or less, that's something to keep in mind. But let's then go to, well, usually the most expensive part. What do you pay a lawyer for? So what will be within those hours you pay a lawyer for? And of course, if we're going for a lawsuit, there will be a preparation of documents, the application itself, exhibits, maybe some additional applications for special mode of notification, safeguard order, affidavits, so forth. There will be a need to prepare notifications. There will be a need to arrange for delivery, and there will be always communication with you about that. And sometimes that's a huge part, because again, some clients, they deliver instructions, then they review the draft once, and well, that's the end of it. Some clients, and they have all the rights to do that, of course, just contact several times a day, send emails, phone calls, ask to correct, provide additional evidence, ask more and more questions, well, like out of anxiety or quite understandable feeling that something should be done right away, and so forth. So this kind of necessary communication, well, it depends on on a law firm. It varies from one law firm to another how it is addressed, but still, it might end up in your invoice. At the same time, your lawyer is not only contacting you or a court office, your lawyer is often contacting the other party. The other party's lawyer. They discuss, they exchange information, what is necessary or required by the Code of Civil Procedure. They exchange documents. They sometimes push each other in the course of some kind of negotiation, because negotiations is a huge part, and most of the time, believe me, you want a negotiation and you want a settlement, because it will cost you significantly less, and most probably you'll have a better result. But again, that depends. Sometimes maybe you are reasonable, but the other party is not. So, well, you have no other reason or no other way but to go into this conflict to the end, because the other party doesn't want any kind of reconciliation, any kind of peace. One of the things your lawyer and the other lawyer should do, or the other party if there is no lawyer on the other side, is to prepare this case protocol, and very often it's negotiation of a case protocol, where the parties try to make it faster, but at the same time as complete as possible. And, well, it's not uncommon, unfortunately, when a party in a weaker position tries to overcomplicate the case protocol in order to postpone and drag the case as long as possible. And then there might be a need to go before a judge for a case management, asking to remove some potentially unnecessary and maybe even abusive procedures from the case protocol. And that all takes time to go to. Not only for waiting time, it's another story. You're not paying for waiting, but that adds to your burden anyway, to your stress. Then, when the case protocol is ready and either approved by the court or just submitted together with the other party, most often situation, then there will be some steps mentioned in the case protocol. Already mentioned the pretrial examinations, maybe some interim or applications, preliminary exceptions. Don't even go there, but there might be many. Safeguard order applications, injunction applications. Usually, if you want to do something about the question until the final trial, because you will be waiting for the final trial, usually more than a year, sometimes for years. So if there is something going on in between, you'll need, or the other party will need, an interim judgment, and therefore there will be interim hearings about that. And that's another story. Not only preparation, but hearing itself. It's hours in court, depending on, again, if you have a more or less complicated issue. It might be several hours, it might be even a day, maybe even more than a day of an interim hearing. And again, you're paying by the hour for your lawyer to be there, but you also pay for preparation. And usually it's about twice as much time to prepare as it will, or sometimes even more, depending again on the situation, on the research required, if it's a very complicated case, if there is a lot of pieces of evidence, and if your lawyer would require some advice of some specialist regarding, and so forth and so forth. So you never know. And fortunately or unfortunately, depending on how you see it, often your lawyer cannot rely only on your comment, on your conviction, on your convincing, pushing an argument. Very often your lawyer would have to verify independently, your allegations, the documents you provided, and the documents you have not provided. The lawyer might need to find them, to look for them, to order them somewhere. Again, administrative costs and the hours and so forth. Of course, if you're a good cooperator, if you just trust your lawyer and you take care of legwork on your own, meaning that your lawyer tells you, I need this document, and then you just do whatever is necessary and provide, then your legal fees will be diminished because of that. But you will be more involved. Some people are ready to be more involved. Some people think that a lawyer provides comprehensive service and everything should be done by a lawyer. Most of it can be done by a lawyer, but at an hourly rate again. So this is something to calculate in advance. So as you can see, when it comes to calculation of your possible expenses, of your possible fees, when you deliberate if you should go or you should not go into a litigation, when it comes to defamation or basically any other civil litigation, but for the questions of justice itself, not even fairness, but justice, like legality, lawfulness. But for that, there are always questions about, is it worth it at the end of the day? Sometimes it is, even often it is, but even more often it's not. and in order to avoid a significant disappointment after, it might be a good idea at least to try to calculate some average, some approximate, some at least level of your future expenses, and compare them to the result that you're going to achieve in the best case scenario and what might happen in the worst case scenario. Because in the worst case scenario, one of the things that might happen, you might end up paying the other party's legal expenses if it's proven before the court that your application was from the beginning not so much founded, or if your behavior during the litigation was like beyond the limits of the Code of Civil Procedure. But about that there was another video about abuse of procedure. So these are the considerations. Let me just remind you once more. So there are various sorts of payments that you might expect if you plan to go for litigation, and there are various sorts of legal work, lawyer's work itself, which of course you can try to do it on your own, but unfortunately in our legal system very often, simply because you do it in a wrong way, you might lose even if you have a valid claim. So again, it's your judgment call at the end of the day, if you want to take that risk or not. Before I finish today, I would like to remind you that this is all just legal information, and if you have your own particular case, it's a good idea to consult your own lawyer. Thank you, and have a nice day.